Hello. In this clip from our Justia webinar, Thriving at the Crossroads of Law and Business in the AI Era, Tom Shack will discuss the differences between a profession and being a professional within a profession. If you want to see more Justia videos on law practice and legal marketing, please subscribe to our channel.
All right. So now that we know a little bit more about morals and ethics, and we're going to go into it a little bit more down the stream here. But what is a profession? We have to identify that. In the early days of, say the early 1900s, there were really two and possibly three professions as we know them today. And it was a kind of a very snobby approach. And there were three groups that basically were thought of as professionals. First was doctors, as we've described before. The second is lawyers, which has been a consistent profession for hundreds of years, and also we add accountants into that too at some point during the 1900s. So those three groups were typically thought of as professionals, and that's not meant to insult anybody. I mean, if there are certainly in our society today, we've evolved where we consider multiple occupations as a profession. So, what is a profession? It's a self-regulated occupational group capable of legally prohibiting others, including incompetent or unethical members, from practicing. Sound familiar? Well, that is why law has always been considered a profession. That's why medicine has always been considered a profession. But today, those concepts extend to. They can extend to all kinds of different occupations that require licensing or have an independent, group of overseers that are picked by the professionals themselves. So that is, that's where we are today. And I think it's very, very important just to understand that you have to be in a position. I'll go back one second. You have to be in a position to understand that we're obviously not the only profession. And now there are dozens of professions. I mean, you could have real estate real estate agents who are, who take an oath under or have to operate under a legally prohibiting or leadership plan or program. So just keep that in mind. All right. Now, Rule 1.4. This is a discussion about communicating, and I kind of got into this with our 1.3 discussion, but I think it's very, very important to tie these two together. So the ABA model rule 1.4 is communicate, right? So a lawyer shall promptly inform the client of any decisions or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. All right. So what do we mean by that typically? Well, you don't just go in to in my case, as a former prosecutor, I just didn't go into court and resolve a matter without having some approval or putting myself in a circumstance where I had the consent of the people that I was working for. In that case, it was the state. But on the other side of the aisle, now as a defense attorney, it's quite a different thing, because we keep our clients up to date on a weekly basis, and we utilize technology to do that. No matter what, no matter where our client is in the world, and no matter who it is, we always make ourselves available for the attorneys to do a Zoom like this with clients, and the reason is we want to make sure that they're informed all the way along. And if we've got nothing to update them on, then we tell them that. And we let them make the decision of whether they want to have the meeting to ask us additional questions. Now, this is not, it's not a question of billing. It's not a question of anything else. For the most part, these are things that we do out of a sense of duty to the rules, as opposed to something to to build the client for. So keep that in mind. Also, you have to reasonably consult with the client about the means by which the client's objectives are to be accomplished. So there's a tricky one as it relates to AI and or the business environment. And I should mention one other thing, and that is that when we were discussing what a profession is, we are not discussing business, right? We're not discussing all of the business across and the business transactions that take place across the world. We're using business as as an umbrella, so to speak, where there may be professionals in the environment, and there may not be. But we're going to have an interesting example that we'll discuss in a few minutes. All right. So when you're using AI, or if you're using a system, you have to make a determination if under Rule 1.4. The means by which the client's objectives are to be accomplished. If you're going to be utilizing AI, you have to make the decision, and it's a difficult decision to disclose to your client. And there may be a host of different reasons why you might not want to, but these rules would suggest that it's probably a good idea to indicate either in your retainer or in your presentation to a client that that you utilize the most modern technologies, right? You utilize artificial intelligence. That's just a disclosure that's not going to hurt anybody, and you're going to seem sophisticated, right? If in fact you are using an AI system. All right, 3, you have to keep the client reasonably informed about the status of the matter. Okay, there's why we do this weekly Zoom check-in with our clients when possible. So you have to make sure that you keep everybody, keep all the wheels moving, so to speak, as you make progress within a case. And that's always tough too, right? And historically, it's always been through, a letter. When I started in practice, 20 some odd years ago, it was, we still use letters. Send out a letter to a client just to make you're producing paper so you can show, what it is that you're doing. Well, today's really no different, but there are other modes that we have come to rely upon. One is a situation like this where we're communicating via Zoom or some other virtual platform. On the other hand, we don't typically, and in our practice in particular, we have gotten rid of the paper model. It's just a whole lot. It's hard to change over to it, but once you're over and utilizing a non-paper, where possible, a non-paper based system, things happen a lot faster. You move a lot faster. You're able to communicate more. And so these are some of the advantages that we've gathered as a result of our own change in how we communicate as a practice. Here's where a lot of lawyers fall flat, right? Promptly comply with reasonable requests for information. The worst thing in the world is to have a client that keeps calling the office and they're talking to somebody who's, not their attorney or not an attorney, and they're told, they'll get back to you. Well, it's really, really important to understand that, that the most important aspect of the client relationship is trust. And if you're not going to get back to me as a lawyer, what makes you think that I'm going to, obviously I'm feeling some anxiety, but, with whatever the information is that I want, or the update that I want. But you should always take the time to do that when possible. And look, we've all had the client that, there's one client that out of 10, it takes up 90% of your free time, so to speak. And then the other 9 take up 10%. They don't, they're not rattling your cage. So just keep that in mind, right? That, that you're going to have those situations. It's okay to have those situations. You're going to have to give certain clients more information and keep them more plugged in on certain items if you're going to comply with Rule 1.4. And then also, you have to consult with the client about any relevant limitation on your conduct. When the client expects you to do something that is beyond or not permitted by our rules of professional conduct, that's kind of where things tie in it from a business standpoint. And I'll use another quick example. I was the general counsel for a national company based out of Washington D.C. And we had experiences where, and I'm sure there's any of you that have worked in-house or are working in-house understand this, that the limitations that are put on me as a general counsel are quite different, obviously, than those that are not lawyers. Now, for me, it was always reassuring to have people who had JDs or were actually members of the bar, also in leadership positions, because it allows you to speak a little bit differently and to be more clear relative to your responsibilities. And the reason I say that is because in this particular world, right, the world of, we're still in a world of startups, and we're still in a world of evolution, particularly as it relates to, to AI, but let's face it, we're evolving from a technological standpoint, more than we can pretty much keep up with. So I think it's very, very important to understand that, that you are often in a conference room or on a call with people who don't have to live by the same rules that you do. And it's just very important to set that table in advance. The worst thing in the world you can do is to take an in-house position, go to your first meeting and then say, or, your first, second, third meeting. And then on your fifth meeting, say, hey, by the way, I can't, talk about certain aspects of this. I mean, you need to be upfront with people. And if, and you need to make sure that you're staying up to date, not only on the legal rules yourselves, but also making sure that other folks in your environment understand that, that there are certain things that you cannot do and you cannot participate in. Not saying that you should tell people, oh, don't include me so that you can go do something nefarious. I'm not saying that at all. What I'm saying is that there may be other things that are, okay to do in business that are just simply not okay to do as a lawyer. All right. Now, B, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation, right? So again, this is where your communication has to meet your audience. If I send a brief designed for the Supreme Court to one of my clients who happens to be, incarcerated, I have to make sure that, I'm not just providing him with the brief, but that he understands what I'm providing him with, right? And so I have to, I always, when I'm doing Zooms with clients, I always go over the information that they reasonably need. And I always go beyond reasonably. I mean, I just give them as much information as I possibly can. But really, you have to make sure that your client is in a position to be able to make these informed decisions. All right. So we talked about what is a profession. Now let's discuss for a minute, what is a professional? Because it's really the professionals, where we are where the rubber hits the road, as the colloquialism goes. So what is a professional? Somebody who possesses specialized knowledge and skills, belongs to and abides by the standards of a society, and serves an important aspect of the public good. Again, we've used that term "good" over and over again, and it's it's important that it stays in the back of your mind. So, with those things in mind, you can now think through, how the term of professional has evolved, particularly in the past 100 years. There are a number of different societies and a number of different areas of specialized skill that are maybe not considered historically a profession or a professional, but today they are. And so you have to be aware that when you're advising a client who's in a particular, business or industry that requires that specialized knowledge, you should be making sure that they understand, your client understands the difference between their obligations, if a conflict comes up, between their obligations as a society and your obligations as a member of the legal society. So that is a boiled down version of what is a real professional. All right. Now we get into one of the sticky areas, ABA Model Rule 1.5, and that's fees. So a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. And you notice the asterisk there. We'll get to that in a minute. Just keep this in mind. As we evolve and as AI becomes more suitable, more accurate, more capable, there's going to be, a real shift in the way we do work, and in some cases, in the work that we do. So you should pay attention to that. Pay attention to your particular industry, your particular legal field, and you should be learning now. If you haven't already, you should be really following what's happening in AI and in legal evolution. The reason that this is so important is because as we evolve into AI, it takes less time to do things. So, if we have more time, we can potentially take on more clients. But you just have to be careful about the concept of, okay, I'm going to charge. I'm charging by the hour, or and what used to take me 2 days for in the law library or in Lexis or Westlaw, it can be done in 5 minutes, and and it's not okay. To be clear about that, it's not okay to go by your old billing standards for that kind of work. If you get the work done in 5 minutes and you can go off and play golf, that doesn't mean that you get to charge that time to your client, because that's what they were expecting, or that's still a reasonable fee. So just watch out for that. All right. Again, and as it relates to fees, this is not comprehensive and only outlines the basic premise of the rule. You got to see the rules for a complete description. And again, I have the proposed rules link in this particular slide and throughout.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.